Yes, he has had 2 parenting time visits prior to being incarcerated, and those took place at the office supervised by us. There were no significant incidents or concerns during the parenting times.
And is it still the agency's recommendation then to continue parenting time in that manner?
After the hearing on the 8th, I did immediately make connection with Brittany Moore, and she did say that she would be willing to make a recommendation on dad and mom's parenting time. So we would recommend parenting time for dad after that recommendation.
Okay. Okay. Let's see. As relates to the case service plan, I'm going to shift gears a little bit. So as it relates to the case service plan, were you able to discuss the case service plan with Mr. Deakins or develop it in collaboration with him?
Yes, I did.
And do you believe that it adequately addresses the barriers to reunification?
Yes, I do.
Were there any other services that Mr. Deakins was able to identify that you might have included on the case service plan?
The only thing that we discussed was some concerns for substance abuse, and he said he would be willing to take voluntary drug screens.
Okay. Will
So
those screens, okay. And will those screens be through LDC? You know?
Forensic fluids.
Okay. Is there anything else that you'd like to report today to the court for purposes of this position?
Not at this time.
Okay, thank you. I have no further questions. Your Honor, move to admit the court report with the attachments. If I'm not mistaken, you had submitted the ICWA documentation at the last hearing.
That is my recollection as well. Do you want me to omit those then for today, or do you want them admitted again?
Let me just confirm, Ms. Madrid, the ICWA documentation you provided in this court report, is it duplicative from the one with mom's court report?
Yes, it is.
Okay, then yes, Your Honor, I would like to omit it.
Well, actually, I've just got that maybe we omitted it at mom's initial this one. I'm just gonna. Okay.
I believe you asked for it.
Yeah, we're just gonna make it right. The BIA, the inquiry, the mailing receipt and the green card receipt indicating that the BIA got the inquiry for all 3 children. So one more. Okay, did you have any objections?
No.
Yes,
I have, thank you.
bless you. All right, they are admitted. Cross-examination for this witness, Mr. Brooks.
So let me see if I understand this. At this time, my client, you're recommending no parenting time, is that right?
Yes, until we get the recommendation from Brittany Moore.
Which could be how long?
I anticipate about a week.
How many visits has he had with his kids? For how long?
An hour and a half.
And there were no issues.
Correct, there were no issues.
What do you hope to find out from this business with Brene Moore that you don't know today?
She could give a clinical perspective as far as recommending what's safe for the children and being around dad.
So can I, but it's not gonna change anything. You think the kids want to have their father, based on what you've seen? Do they seem to enjoy being around their father?
Yes.
How old are they?
13, 14, and 6.
So they're adolescents.
Yes, the 2 groups.
Now what is the most egregious allegation? I mean, I see you say physical abuse. You're talking to a 76-year-old man who was raised by Adrian Dominicans, educated by. So I know a little about physical abuse and corporal punishment. What was abusive?
Well, I do not have the petition right in front of me to remember the allegations, but there were allegations of physical abuse and domestic violence, a significant long history of domestic violence.
I understand DV, domestic violence. Physical abuse, I really didn't see it. But what, are you afraid that if he goes and visits his kids, he's gonna beat them up at your offices?
No, I would recommend parenting time as we were doing prior to the hearing on the 8th. And now we are looking for that recommendation from Renee Moore for parenting time.
Okay, I have nothing further. Thank you.
When were those parenting times?
It was prior to him being incarcerated on January 24th, once a week for 2 weeks. I don't have the exact dates in front of me.
So the thing that tripped us into thinking to be more cautious about father was that mother made a comment at her dispositional hearing. Do you recall that?
Yes.
And her comment was that, will you remind me, dad was out of jail and something triggered the kids and they had a meltdown. Is that something like what mom said?
Yes.
And do you know the whole story of that event from the kids' perspective and from the placement's perspective?
From my understanding, the kids have had significant, outbursts and things like that, anger towards mom. But at both of the supervised parenting times, there were no incidents with the children.
And the night that the kids had their meltdown about dad, weren't they really melting down because mother was trying to bathe the 6-year-old and she was going in, it was about mom and the 6-year-old can bathe themselves?
Yes, so they're working towards independence with Connor, and that was triggerous for Stormy when mom was bathing Connor and not allowing him to do it on his own.
So there was a lot of things that led to that. It was part of what was upsetting the kids, something about dad?
Not to my understanding, I believe that they had listened to the court hearing, but that was after.
Okay, so you did trauma checklists for the children and these are quite elevated, would you agree?
Yes.
So we've got the oldest child with a score of 12, the middle, 12, the youngest with a score of 11, and the oldest with a score of 14. Will you be recommending a trauma assessment?
Yes.
Okay. The placement is meeting all of the needs.
Yes, they are.
And so if Ms. Moore has a chance to see the children, will she also see the father?
Yes.
And then would you expect then that she'll give
Here is where things become more complicated. Testimony reveals that the children's emotional reactions may not have been directly connected to their father at all.
a recommendation, you said within a week or so?
Yes.
It seems to me like we gave mom a lot of visits, like 4 times a week, and then we'd have to work dad in there schedule wise, right?
Yes, so how we were doing it was dad was visiting on Mondays, and then mom's visit was 30 minutes after at the caregiver's home.
At the caregivers, okay. So dad is unemployed at this time?
Yes.
And will you help him get into some employment rehabilitation services?
Yes, I will.
Okay. So dad isn't being punished by his visits being paused, is that true?
Yes, that is correct.
You want to check on the needs of the children and whether dad is prepared to parent the children since his incarceration, since so many facts have changed, correct?
Yes, just safeguarding the children and their needs.
Okay, thank you, I have nothing further.
Do you know what dad's housing is right now?
I believe he is living with his father-in-law, if I'm not mistaken.
Have you done a home investigation?
I'm not.
Do you know what the status is on the criminal charges?
I was not able to get a copy of his bond conditions, but I am working on
Can you add to that homework list a register of action? So that we know what the status is on his case. Have you scheduled the trauma assessments yet or made those referrals?
They are not scheduled yet, but the referrals are made.
Okay. Are the children in counseling?
Connor is in counseling with CMH. Lily just had an intake this week with CMH. And Lily, we are working towards getting her into services.
Okay, will she also go through CMH?
More than likely, yes.
Questions, based on my questions, or any redirect, Ms. Thomas?
No, Your Honor.
Mr. Brooks?
Let me see if I get this straight. There was concern at the last court hearing about some outbursts that occurred with the children after my client got out of jail. But the outburst occurred because of something the mother was doing, whether it was appropriate or inappropriate. Something the mother was doing. So the net effect was you stopped my client's parenting time?
It was my understanding that that was based off a comment the mom said during the hearing.
Yeah, about outbursts, right?
Correct, and that wasn't further explored at the last hearing.
What kind of parenting time does the mother get?
She visits 4 times a week.
Thank you.
Any other questions?
Regarding dad living with his father-in-law, are these people planning together or are they planning separately for reunification?
Are you saying mom and dad?
Yes, mom and dad.
It's my understanding that they're planning separately.
With respect to the bond conditions for dad and the register of actions, both of those are something you could get through district court. They denied you access to those documents today, is that true?
Yes,
And you were specifically asking for bond conditions.
yes.
The children are, some of them, girls probably, are seeing their counselor who is a social worker through their school, is that correct?
Yes.
And they see that person pretty regularly
Through family medical, yes, once a week.
through family medical, not through fostering solutions,
Correct.
family medical. Okay, is that person prepared to make reports for court?
I have not been able to make contact with her yet, but more than likely, yes.
Okay, thank you, nothing further.
Thank you for your testimony. You may return to your seat. Further testimony today, Ms. Thomas?
No, Your Honor.
Mr. Brooks?
Anything you want to tell the clerk? No.
All right, Ms. Chanel Deakins, I would like to hear from you. We need to explore the allegations that you placed on record last week and any concerns you have on parenting time. Deputy Ames, would you please swear her in?
Can you raise your right hand, please? Let me know when it's raised.
It's raised.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, Ms. Deakins, go ahead and tell us about what happened and your concerns, please.
So last week I was bathing Connor and he had an accident. I was making sure that all the poop got off his bottom. I had given him his own washcloth to wash the rest of his body. And Stormy had came in yelling and screaming, saying he's not attached to your uterus anymore. He can do this by himself. All I was doing is helping him get the poop off his bottom and making sure it was all gone because he's been having accidents every day. And I didn't know prior to this that he was bathing himself and doing a good job because no one had relayed this to me. And when I got him out of the tub, I went to go give him a towel. She yelled at me for giving him the wrong size towel. I gave him a towel that he could wrap around his waist and go to his bedroom and get dressed. And I took it as if, okay, they are upset. They had just seen their dad. They are upset about that. And when I talked to him later that week, that wasn't the case.
All right, thank you. Questions, Ms. Thomas?
No, Your Honor.
Mr. Brooks?
I have none.
Ms. Heiss?
Ms. Deacons, at that time, the bathing of the child, you said that the middle child was upset. Were the other two children upset as well?
Connor said I was wiping too hard. Lily screamed from the other room, at least dad can follow the rules. Why can't you? I don't know what she meant by that.
Okay, and the whole issue that night about the youngest child having a mess in his pants, that was something that was upsetting you, or is that something that was, tell me about that.
He just needed a bath because he had messed in his pants.
The discussion moves beyond individual incidents and into control, communication, and influence. Questions about text messaging, phone access.
And it was his bath night.
So fast forward, you went to your Monday visit this week, yesterday, to a choir concert. Is that true?
Yes.
How did that go?
It didn't go very well. Stormy didn't end up performing, and I had asked her to come sit by us if she wasn't going to perform. And
isn't it true that they were yelling and screaming going on?
Yes, they were yelling and screaming about the court, that I twisted my words, that I'm a hypocrite, and I got dad's visits taken away.
And your solution was to take Stormy home from the concert? Is that what was happening?
No, we were going to Fostering Solutions to have a visit. That wasn't my suggestion. That was Jessica's.
Okay. All right. So there was a supervisor that was there at the choir concert, right?
Yes.
And did that person have to separate you and the kids?
She just suggested that, she said that the kids could stay, the older two.
Because Stormy wouldn't get any credit for the choir concert if she didn't stay, right?
I don't know. I don't know. She didn't even go on stage.
Have the girls talked to you about not wanting to go to visits?
No, they have not.
They've never texted with you that they don't want to visit?
No.
Are you using the group chat to text with the children?
Yes.
How often are you communicating with the children through group text?
I try every day to say good morning and have a good day. And I most of the time try to tell them good night.
Can you tell me a little bit of something about your position about the kids being involved in the court hearing?
I don't think neither one of them are mentally ready to understand what's going on.
And so you did what about it?
I blocked YouTube on their phones.
So as a consequence of them having access to the court hearing, you blocked the YouTube app on their phone, correct?
Yes, and I think as a mom, because Lily also watches inappropriate things on YouTube, I have the right to do that.
What other apps have you blocked since the kids have been in placement?
No other apps.
Have you, but you're in control of the kids' cell phones, is that true? You could turn them
Yes.
off at any time? Yes.
Yes.
Okay, thank you, Your Honor. I have nothing further.
All right, thank you for your testimony. Anyone else you wanted us to hear from today, Ms. Heiss?
No, thank you.
All right. Comments in closing, Ms. Thomas?
Your Honor, I think that it's at this point, for the sake of everyone, the agency is asking this court make clear instruction regarding parenting time for each parent regarding the frequency and duration. That's not usually something we ask for because it's something we typically can find, you know, a reasonable solution to during a family team meeting or something, but there seems to be a lot of issues here. And until there's the assessment with Ms. Moore, some clear guidance from the court would be very beneficial for all involved. And with that, we are just asking the court order Mr. Deakins into his case service plan and set this for a review, which I believe the court had intended to do with mom's review on 4/23 from 10 to noon. And with that, there's nothing else. Thank you.
Mr. Brooks?
It's very difficult for me this morning not to be sarcastic. This guy has done nothing to deserve this, not a punishment. He's getting his parenting time cut off. Mom gets 4 times a week. The testimony is clear that the 6-year-olds and other one's reaction to something involving the bathing of a child has nothing to do with my client, nothing. But the department thinks my client's parenting time should be cut off until we make sure he's okay. Well, this really stems from a modern bias against corporal punishment. A bias I don't share, but I am 76 years old. I don't think there's anything wrong with some corporal punishment. But I think what's going on here is Dad has been painted as the bad guy. Let's extrapolate from a story about bathing to the kids are upset and afraid or something of their father, when in fact the testimony is apparently just the opposite. So, number one, I object to the cutting off of his parenting time. Number two, I think it should be increased.
Thank you. Ms. Heiss?
Thank you, Your Honor. Now I don't want the children to watch the video. This is not a corporal punishment case. The father has accepted adjudication for the entire scene that was happening at the household, and we have agreed to protect the children and help the family with services so that we can reunify with a healthy family. This is not a corporal punishment case. This is different than that, but we need to break the control that the children are doing really well in this placement. The placement is close to both parents. And I think that if we were to put supervised visits at the discretion of the agency, when Brene Moore approves, that the agency might take away some of the times that the mom is visiting supervised by the place.
This section reveals something important. While disagreements remain, there is growing consensus regarding the broader service plan.
They're good people, but I don't think they're understanding that they can assert control over the children and mother. They're doing certain things with bedtimes and they're doing certain things with structures and a little guy bathing himself. And I think that it's an appropriate placement and they intend to help and support the family. But I think some of that supervised visits that mom's having is not working out. The children are asking to reduce the amount that mom visits. They're also asking to have visits with dad. So we're gonna get a check on from the therapist before they get that supervised visits with dad. I would ask you to consider ordering no contact outside visits I thought we discussed this at mom's hearing, but the kids don't need to be controlled or contacted they need a break in the pattern that this family had been in. They need a break, and they want to know that during the break, mom is working on herself and dad is getting services he needs to get to be employed and housed, and all the domestic violence cycles broken. They've lived with this upheaval and instability for a long time. They want a break. So no contact outside visits. I would ask you to order that the cell phone status remain as it is today, at least. If any changes need to be made, we could have a family team meeting so that if mom's budget is cut and she can't afford it, that we can discuss that rather than mother. The kids feel control. If they don't please mother, she messes with the phones, and the phones are really important to the kids. So that concludes my comments. Thank you.
Yeah, I want to note for the record that I did receive the trauma screenings. I had ordered those to be produced, but I would offer to the attorneys any opportunity to object to those becoming part of the record at this time.
No, I have no objection.
I have no objection.
No objection, Your Honor.
Thank you. Thank you, Ms. Madrid, for your testimony today. All interested parties were given notice for purposes of today's initial disposition. The issues are adequately addressed in the case services plan that's been presented to the court. It does not look as though it's been, I have a signed copy by Mr. Deakins. Deputy Ames, would you take this across to Mr. Brooks and Mr. Deakins to make sure that this is the plan that they are satisfied with before I make that final decision? While you're having a look at that, I do want to say that I do find reasonable efforts towards the goal of reunification are being made in this case by Ms. Madrid, as well as that Ms. Heiss is in satisfaction for obligations as covered in that item. Thank you. Reviewing the file, the reasons that these children are in care right now is because of the history and patterns of domestic violence in the home that did occur in front of the children. My recollection, and it has been a minute since we had the trial, but my recollection also is that one of the children called at the last time that the domestic violence was exposed in the home. And that this is a longstanding pattern that helps contribute to the very high numbers that we saw on the trauma screenings. There are also indications both in the no contest plea that was submitted by Ms. Chanel Deakins, as well as that came out during the trial of Mr. Aaron Deakins, that what we're dealing with as it relates to discipline of the children is it cannot just be characterized as physical or corporate punishment. It is the day-to-day management of the children in a way that could potentially be characterized as child abuse. So those are the things, one of the main things that need to be addressed in this family. If they're planning separately, clearly we're going to need both of them to establish housing, employment, and show us that they're able to support the children, including the extended needs that they have demonstrated by way of the trauma assessment. I'm glad to see that we have had some initial recommendations made, some screenings through CMH. There should be no prohibition against allowing both parents to participate in the bonding assessment that will be part of the trauma assessment. So please make sure that those opportunities are extended to both parents, as well as tackling any additional recommendations as a result of those pending psychological evaluations or trauma assessments. Ms. Madrid is very familiar with that particular process. So I know those will probably be well underway by the time we get back here next time. Mr. Brooks, have you had a chance to talk with your client about the case services plan?
No, Your Honor, he's been looking at it. You got any issues with it? You don't agree? Everything else? My client tells me he agrees with the drug screens, but doesn't agree with any other part of it.
Of the entire case services plan?
Correct.
No, I agree with the rest of the plan. I just don't need to do the substance abuse assessment.
I had it exactly wrong.
Sorry.
That's okay. So
He doesn't agree with his need for substance abuse screening. He agrees with everything else.
The judge delivers the most significant ruling of the hearing. Supervised visitation remains in place for both parents, but visitation is not suspended. Instead, professional oversight,
Ms. Thomas?
I think I think it is appropriate to leave that portion on. But I also believe that it typically is a second assessment. Typically, I think it's included in our psychological evaluations. And then there's an indication or recommendation for further assessment. So if we want to table that until the review to determine, if the psychological determines further assessment is necessary. But I don't think it's going to be overburdensome to dad at this point in time.
Ms. Hyde?
I think at least it can be a lower priority and agreed to happen later after we see some screens. I don't recall that substances were a big part of the case. I think to get the DV issue with Mr. Bailey is going to be primary. So whether it's a lower priority or off the plan until we have positive screens, either is my recommendation.
Thank you. Mr. Brooks, I have seen in our psychological evaluations that that particular professional does explore that issue. Would you be comfortable, or Mr. Deakins, would you be comfortable with allowing that to occur, and then we'll revisit the substance abuse screening after the psychological, if necessary?
If they get if you guys get a positive screen from me, then I see a reason for it, but other than that, I don't use, so I don't see a reason for Narcotics Anonymous.
That's different than a substance abuse screening. A substance abuse screening or evaluation just as you having a conversation with a professional about whether or not you have a problem.
Oh, that's fine. I'm sorry.
Oh, that's all right.
I misunderstood it.
All right, well, if you're comfortable then with the terms, feel free to sign off on that. That will become the document that the court uses to measure progress in the case. So if you have any other comments or questions, now's the time to scroll down. It should also be something Ms. Madrid explores with you on a quarterly basis. Okay, that's me.
Sir?
Deputy Ames, I do now have a copy of that case services plan that has been signed by Mr. Deakins. For the record, I am satisfied with the case services plan and also with the plan that the psychological is the mental health assessment is the first and foremost issues, and that substance abuse assessment is really not a priority at this particular moment. So we have that, but we do have the indications of the patterns of the family that need to be addressed, as well as the housing and the rest of the issues the court's already looked at. As it relates to visitation, I'm going to order a supervised visitation for both parents. I have some concerns about the allegations that came up about dad's parenting time and some of the concerns that were raised by Ms. Heiss about some of the dynamics that surround visitation and mom's potential effect on the children as it relates to that. I'm going to ask the department to issue 2 visits for mom per week and at least 1 visit for dad per week supervised. We'll ask at this time that the supervised visits for dad be by a professional, and that includes by the agency or by Ms. Brene Moore. So dad's visits should be at least once weekly, if not twice weekly professionally, closely monitored by our professional in this case, which is Ms. Moore has volunteered to do that, which I appreciate. And if she recommends differently, then please follow her recommendations and implement those, especially if she's able to give you an opinion in the next few weeks. Please don't wait another 60 days before you implement those. So I'll try to articulate that the best I can in the order, but basically it would be 2 visits per parent per week maximum, but should be tailored to mirror any recommendation by Brene Moore between now and when we come back. Dad's visits should be supervised by a professional in the meantime. No contacts will be allowed outside of visits. And I look forward to further information from the trauma assessment about what we can do to support the kids. There's clearly a lot going on with them. and a lot of trauma that needs to be processed that will continue, I'm sure, to manifest now that they're in a comfortable and stable setting, which I'm glad to hear also at this time. So that will be the order of the court moving forward on parenting time. I did not hear a risk of harm associated with parenting time at this juncture, so I'm not going to suspend his visits. That will be as previously indicated. The children are in the safest and least restrictive placements at this time, pending our next review hearing. I will, Ms. Madrid, I would indicate to you that a lot of the register of actions and information on people who are going through district court is available online. So hopefully between now and when we come back, we'll have a better idea of what's happening with Mr. Deacon's case. I'd like to have that documented for the file, please. You'll also have to make sure that you're following any bond conditions. I don't have any control over whether or not you would get violated downstairs.
Nope, I understand completely.
Very good. So if there's some bond condition out there that says that you can't see the kids,
There's not,
all right, don't go in there and tell them that I said you could, because it won't help.
no. No, the bond conditions are just against Chanel and the household, not against my kids.
All right, I'll be careful around those. That will demonstrate, respect for that court and respect for the rules in general, which is something that would be great for you to establish moving forward.
But for the children, do you see it necessary is really removing Chanel from the visits that she gets?
I do. And once Renee Moore weighs in on things, we'll know further on that point. And that will become within her discretion.
I just don't want to see the kids getting hurt from removing us out of their lives even more.
Well, I already talked about this, but your kids have been through a lot. Okay, they are scoring extremely high on our trauma screening assessments. So what that means is the best thing that we can do for them right now is to offer them a stable environment with routine and a break from you and Ms. Deacons, because that is the environment that they came out of that contained their traumatic experiences. So continuously introducing them to that by way of visitation with their mother potentially could be harmful to them. And that's what I'm looking to ensure against. That's also why I'm asking for a professional to weigh in on it. All right, for purposes of review, I'm looking at May. I'm sorry, April 30th. We have the 9 o'clock hour open on May 30th.
Judge, are we still, I'm sorry, are we still holding this with moms on April 23rd?
On April what?
23rd?
Oh, yes, thank you for reminding me. Yes, we have moms scheduled for 9 o'clock, or no, I'm sorry, 10 o'clock on the 23rd. And then we'll schedule your clients for 11.
Which day?
Sorry, so this would be April 23rd.
April 23rd at 11.
Yes. All right, unless there's any questions, that's all for today. I'll have this order out to you in a few minutes.
Thank you, Rob.
Good luck.
The court repeatedly returns to one central idea. Children experiencing significant trauma require predictable routines, professional support.
Thorough exploration of the legal issues in this case pursuant to the sidebar. My take on the conclusion of that, we talked about all of the developments that came from Pennsylvania, recognizing that what we've received and has been circulated thoroughly now to everybody on this case and the guardianship case is simply that it would appear that the guardianship from Michigan the guardianship orders from Michigan have been recognized in Pennsylvania, but do not operate as a separate guardianship. So that raises a question as to if the Michigan court closes the jurisdiction of the guardianship case, if that will effectively close the guardianship authority in the Pennsylvania case, which is a distinct possibility according to some preliminary research done. But we're not really, we're not in Pennsylvania. So that's an issue that Ellie's gonna have to take up with her parents and deal with that, and we'll deal with the guardianship case in a minute. But it causes a problem in the abuse and neglect case because the question remains as to whether or not Ellie Guerin wants to work on reunification with her daughter and what that looks like. The interstate compact investigation that was done into the home of Ellie's parents revealed that Pennsylvania has a slightly different take on things than we do here in Michigan. In Michigan, if a parent, even a respondent parent who may have some issues, is residing with appropriate parents, then placement can be explored in that household with the grandparents. In Pennsylvania, they appear to have a different perspective there. It appears in Pennsylvania, if a respondent parent with challenges is residing with other people like their parents who may not have issues, it doesn't matter. And ICPC has still denied them. So there's the preliminary issue outlined in the one page that we received, which is the shortest investigation result I've ever seen. But there's also some other issues that were raised in this document about domestic violence and untreated mental health issues and the dynamics of the relationship between Tanya Garen and her daughter. That's important to note because that indicates that it's not simply that Ellie with her own challenges is the issue, but there could be additional issues in the household beyond what the Michigan court has identified with regard to Ellie's limitations. That also, this letter has some implications in the guardianship case as well, but we'll take that up when it's time to talk about the guardianship file. The long and the short of it is reunification with Ellie and her daughter appears to have gotten more complicated rather than less in the last report period based on the ICPC investigation results, as well as the development of the Pennsylvania court as it relates to guardianship and how that appears to now hinge on the guardianship authority in Michigan, anyway. So the question as to reunification efforts with Ellie is one that we're going to be looking at trying to answer if it's feasible, because at the end of the day, that's what we're here for, right? If we can reunify this parent with this child. Now, the challenges presented by Mr. Cundiff, the father of the child, impact this review hearing simply because it's also permanency planning. But the particulars of his situation we'll reserve to explore with him during his review period. Other comments on the sidebar at this point, Ms. Thomas?
No, Your Honor. Thank you.
Mr. Winter, you were there for it, and I know you're in the guardianship case, but obviously the guardianship impacts the abuse and neglect, and the abuse and neglect impacts the guardianship. Would you like to make a record on anything that we talked about in the sidebar?
No, Your Honor. I think you did an excellent job. Thank you.
Thank you. Mr. Brooks, anything you'd like to make a record on as it relates to the sidebar?
Only if we all agree that there's really not a whole lot of moving forward we can do. Just kind of pending him getting through a morass of legal issues in the criminal case of Michigan.
Yes, we'll highlight the details of that when it's his review. But yes, okay, very good. Mr. Howitt, comments on our side?
No, Your Honor.
All right, so let's look at Ms. Ellie Garen's case with.
Here's the major turning point. The court formally recognizes that reunification is no longer the only objective being considered.
Purpose with any other questions for any other witnesses today? Actually, we had Ms. Macy Moore was on the stand. Ms. Berger, did you have any more questions for her?
I do not, Your Honor. Thank you.
Okay. Mr. Howard, did you have any questions for her?
No, Your Honor.
Ms. Thomas, any redirect for her?
No, Your Honor. Thank you.
Any other witnesses today?
I have none. Thank you.
Any witness testimony today? Ms. Berger?
Ellie, would you like to testify today?
No, I'm okay.
Okay. No witnesses then, Your Honor. Thank you.
Mr. Howard?
No witnesses.
Very well. Comments in closing as it relates to the permanency planning hearing as well as the review of Ellie Garen's case services.
Thank you, Your Honor. At this time, we'd like to recognize that Ms. Garen is at least engaged in services that support her case service plan. I think that there are a lot of legal issues that have to be resolved. I would anticipate a family team meeting or maybe even a professionals conference where we kind of brainstorm and try to figure out the best path forward and what that looks like for this kiddo, given her very young age, the time, the amount of time that she's been in care, and how long it would take to achieve permanency, given the options before us. So at this time, Your Honor, we would just ask for status quo, with mom continuing to engage in her case service plan, with Ms. Moore following up with those referrals, recommendations, and keeping track of things that mom's doing. And then obviously offering that parenting time as would be appropriate for the child's best interest and safety. With that, we just ask for a 90-day review. I think within that this review period, we should have more information about the concerns from the ICPC investigation. I would like to see a thorough report rather than just the summary. I also think that there needs to be some work done in understanding the difference between transferring the guardianship to Pennsylvania versus registering in the order and letters of authority in Pennsylvania. But again, that's out of our jurisdiction. I just believe that we've all come to the accurate conclusion that what has occurred right now is not sufficient for our court to really let go of jurisdiction of this family at this time. Thank you.
Thank you. Any objection to the court taking into evidence the documents from Pennsylvania indicating the developments on the guardianship? Their file is number 2025-1525. I believe those pleadings have been circulated, but I would be inclined to receive them into evidence as they are certainly relevant. Any objections?
No.
No, Your Honor.
No, Your Honor.
No, Your Honor.
No objection.
All right, Ms. Berger, any closing comments today?
Thank you, Your Honor. I would just like to, I guess, indicate or agree with the department in part that my client is making progress, that she is doing as much as she possibly can, given the distance between her living situation and here in Michigan. She's engaged in parenting, she's attending counseling, she's attending psychological appointments. So I would just ask for another review period to either give her more time to work on these things towards reunification, or for us to come up with a comprehensive plan for placement of her child and her guardianship. Thank you.
Okay. Comments, Mr. House?
Yes, I think it's important that the child is in a better spot medically today than she was a couple of months ago. So I think we're all very happy about that. I think from the reports and speaking or attending a team decision-making meeting, Ellie is doing well in Pennsylvania. She's willing to do what is available to her. She doesn't, turn things down. But as far as, long-term planning and getting some clarity there, I think the conversation with all parties about their intentions as far as involvement with the child would definitely be where I would like to start, and then kind of working through those intentions to match it up with what's best for the child and what options are available to the families would be a good order of operations. So that is something that,
As the hearing approaches its conclusion, the court emphasizes the importance of gathering additional information before making any permanent decisions.
I think our team will be looking to do over these next 90 days. Thank you.
Thank you. The court finds all interested parties were given notice for purposes of today's review and permanency planning hearing. This has been bifurcated. Each parent is entitled to an independent review of case services anyway. But the question of permanency is one that relates solely to the child. As I shared during our sidebar, I think that this report period has produced a lot of information that we were all hoping would give us some clarity moving forward as it relates to the Guerin family. And I think what we've gotten is more questions than answers, and more information that raises more questions as to what should be done to plan for where this child will be moving forward. As I indicated, the ICPC, the Interstate Compact investigation into the request for placement made by Tanya and Patrick Guerin has been denied. So that effectively, as of today, closes off the court's ability to place this child with her grandparents, which is also where her mother is living. But the goal in the case currently, as it relates to the child and the mother, is reunification. So the paramount question is whether or not Ellie Guerin has made sufficient progress in her case services to document that the risk of harm has been remedied and it's safe to send the child home. All of the issues that were raised at removal as it relates to Ellie's limitations are still in place. If anything, we have more documentation about that as a result of work that was done in the guardianship case. Ellie's parents have advocated fiercely for guardianship of her. They secured guardianship of her in file 25-53277DD. Based on the assessment completed by Michelle Liska, which is also part of the documents that were received into evidence today from the Court of Common Pleas of Northampton County, Pennsylvania, the Orphans Court Division, as they call it there, in file 25-1525. But we were aware of a lot of Ellie's limitations before that, and those contributed to the removal, in addition to many of the other issues associated with her relationship with Mr. Cundiff. So those limitations and challenges, and now compounded by the distance, and the child's health issues that have prevented additional bonding opportunities, increase the court's perspective on the goal of permanency. Secondarily, the reservations that were identified in the ICPC letter dated December 26, 2025 from the County of Northampton Children, Youth, and Families Division raised some issues on top of the challenges that Ellie seems to have come to the table with as far as that were identified with Michelle Liska. And that does include, and I'm just going to quote right from the letter, the state of Michigan should further assess the relationship between Tanya Guerin and her daughter, Ellie Guerin, as there is documentation provided to this agency that indicated prior domestic violence and mental health concerns for both individuals. In addition, Tanya Guerin may not have been fully transparent in her mental health diagnoses and or treatment due to her resistance in providing documentation to this agency, as well as medical records that appear to have information omitted. So now we have the mom residing in Pennsylvania with her mom and these additional issues that have been raised. The question that I would like to have, and I'm afraid to ask more questions in this case, to be perfectly honest with you, but I think the next logical question for me to answer in the next report period, Ms. Moore, is whether or not Ellie Guerin can effectively move towards reunification at this point, given her natural born limitations, if you will. The limitations that were identified outside of the reservations that are now raised as it relates to the household that she lives in. Ellie was ordered out of the Cundiff household into the household of her parents without any background knowledge of the risks that were identified by the Pennsylvania investigation. That will be taken up in the guardianship, but regardless of where Ellie is at, can she effectively reach a level of parenting skill that would allow her to assume full parenting responsibility for this child is a question that I need answered. So if that means going back to Ms. Liska with that question, or finding another professional, or simply a deeper dive into the analysis that of the facts and circumstances that we have here, is the task of the department moving forward. Because if she can never achieve reunification because she just simply can't get to that level of parenting skill, then the goal is clearly adoption as it relates to her efforts and the child. So that being said, what I'm going to do today, and I'll go further into analysis with Mr. Cundiff, of course, is create a dual goal. Understanding the developments of this report period, taking into account the fact that this child does appear to have her own developing special needs and can't travel, and some other complications that are further detailed in the court report, but also the fact that the child's been removed since June 12, 2025. We're clearly past 6 months. This is a very young child with significant needs who's developing a significant bond with her placement. I think it's appropriate to recognize at this juncture, this is our second review period, that reunification now has the competing goal of adoption on the same footing. So I'm going to set a dual goal for this child moving forward. Contingent on what further developments may persuade the court, given that Mr. Cundiff's review still, we have to get to that. In the meantime, as it relates to Ellie Guerin, the court does find that her child is in the safest and least restrictive placement. She's not able to be returned to Ellie Guerin at this time. Currently resides in Pennsylvania with all of the limitations that have been established on the record up to this point, as well as the additional concerns that the court articulated on record today. Certainly, there have definitely been efforts towards reunification by Ms. Moore. Deep dive into both how Pennsylvania and Michigan intersect. Thank you to all of our attorneys and advocates and service providers who are putting so much time and energy into this case and this family in order to figure out what's best for this child. So that will conclude for Ms. Ellie Guerin, her review portion today. And I would offer to everyone to return to talk about the case again. Let's see, in April. I have the afternoon of Tuesday. Oh, Mr. Howard's out there. This is spring break season. It gets tricky. All right. How about basically, I have the morning of April 6th. We can set it for 9 a.m.
Works for me.
Okay.
Works for me.
Hearing no objections, we'll set our next review for both parents, 9 and 10, on April 6th, Monday, April 6th at 9 o'clock and 10 o'clock respectively, starting with Ellie Guerin.
May I ask a question here?
Sure.
Why are these hearings bifurcated?
Because of the, the indications of domestic violence, which have now been supported also by the criminal charges. Ellie Guerin's visible reaction to the crossing of her path with Christopher Cundiff at the last hearing further supports that. It's in consideration for Ellie and her mental health, and so that she would be able to comfortably participate as she wanted to, considering how disturbing it has been for her to have your client in the same hearing.
Thank you.
But let's go into your client's hearing. Okay, all right, so the Guerins are welcome to log off or turn your camera off if you wish to review the second half of our proceedings today. As I said, it is in consideration for Ellie that we've bifurcated these, and in consideration of the domestic violence between the two, the current criminal charges. So if you want to log off. I would recommend that you at least turn your camera off. We're going to head into the review portion as it relates to Christopher Cundiff. All right, just for the record, they have terminated their video feed. And I have welcomed Jail Zoom 1 back in. Is it possible for us to have Christopher Cundiff? I know you've been waiting very patiently, and we appreciate your time. We still have Christopher Cundiff from the jail. We may have to take a brief recess to call over to make sure that you can still have it for you. Their camera is off and their microphone is off.
The review ends with uncertainty still hanging over the case. While services continue and reunification remains possible, the addition of a competing adoption goal signals that the court is preparing for multiple outcomes depending on future developments.